While the media chases political drama and celebrity side stories, something historic happened in Washington, and too many people missed it. I'm talking about a Supreme Court decision that never once used the phrase assault weapon ban, yet struck those bans harder than anything in recent memory. This was not a whisper in a footnote or an obscure procedural order. It was a unanimous ruling, 9-0, that reset the legal terrain for everyone who cares about the Second Amendment. Here is how we got here. In 2021, the government of Mexico filed a sweeping lawsuit against some of the biggest names in the American firearms industry: Smith & Wesson, Glock, Colt, Ruger, and others. The claim was straightforward to say and explosive to prove these companies were fueling cartel violence by allowing their products to be trafficked across the border into criminal hands. Mexico did not argue that the manufacturers broke American law when they sold their guns. Instead, it tried to pin corporate liability on crimes committed by third parties: the smugglers, the corrupt dealers, and the cartels that pull the trigger. The first stop for that lawsuit was federal district court, and the result was dismissal. The judge pointed to a 2005 federal statute that most people outside the gun world barely knew by name: the Protection of Lawful Commerce in Arms Act, or PLCAA. Congress enacted PLCAA to ensure lawful sellers and manufacturers are not bankrupted by lawsuits when third parties misuse their products. You cannot sue an automaker because a drunk driver plows into a crowd. And by the same logic, you cannot sue a lawful gunmaker because a criminal misuses a lawfully sold firearm. Mexico appealed. The case drew headlines, op-eds, and a wave of international attention. Eventually, it climbed to the highest court in the United States. And then came June 2025. In a rare moment of complete agreement, the Supreme Court issued a 9-0 decision in favor of the gun manufacturers. No dissent, no fractured coalition. The court spoke with one voice. A foreign government cannot use American courts to punish American businesses for crimes committed by other actors in another country. That alone would have been a major victory for the rule of law. But the story does not end there, because tucked in the opinion was a sentence that reverberates far beyond that lawsuit. The opinion was authored by Justice Elena Kagan, despite rumors trying to credit someone else, and inside it was a clear, powerful line that cut through years of political fog. Firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. Read that again. It is not a throwaway line. It is the Supreme Court speaking about the status of the most targeted rifle in the nation. Why does that single sentence matter? Because in modern Second Amendment jurisprudence, a simple test carries weight if a class of arms is in common use by law-abiding Americans for lawful purposes. Government cannot ban it. This principle was set down in District of Columbia vs. Heller in 2008 and reaffirmed in New York State Rifle and Pistol Association v. Bruin. Those decisions reject the notion that politicians can outlaw a category of arms simply because it looks scary or shows up in sensational headlines. Legislatures can regulate the margins. They cannot erase the core. That is the line. Now, layer in the facts. According to industry data, as of 2025, there are more than 24.4 million AR-style rifles in civilian hands in the United States. These rifles are used for home defense, competition, hunting, and recreation, plainly lawful purposes embraced by millions of responsible people. When the court says that AR-15s are widely legal and commonly owned, it is acknowledging what gun owners already know. Once you accept that reality, the legal conclusion follows: the platform is protected, and blanket prohibitions run headfirst into constitutional guardrails. This is why that single line, tucked into a case about an international lawsuit, changes the dynamic everywhere. It gives attorneys a bright, simple marker to point to when they walk into court. They do not need to relitigate whether this is a fringe platform or a mainstream tool. The Supreme Court has already told you. You can feel the shift the moment you say it out loud: widely legal, commonly owned, lawful purposes. That is the standard, and AR-15s meet it. Courts notice clarity. Ambiguity no longer shields weak bans. Let me keep the pacing tight, because the implications are already moving. We are not discussing an academic theory. Courts and legislatures have treated AR-15s like political props for years, writing laws that chase appearances instead of constitutional limits. When a unanimous court signals that the rifle at the center of those laws sits inside the core of protected conduct, state-level bans are suddenly standing on thinner ice than ever, and that is where we pick up next. I am going to connect that sentence to live cases and real-world numbers, the places where the legal dominoes are already wobbling. So you can see exactly how this ruling turns into results in the courtroom and relief for ordinary, law-abiding owners across the country. That one sentence did not just stay on paper, it lit a fuse. When the Supreme Court declares that AR-15s are widely legal and commonly owned for lawful purposes, every lawyer challenging state bans suddenly has a constitutional weapon of their own. They can walk into any courtroom in America, hold up that unanimous opinion, and say the highest court in the land has already settled the question. That is not speculation. That is binding precedent. Judges know it, attorneys know it, and the opponents of gun rights know it too, which is exactly why the ground is starting to shake beneath them. Think about the simple logic at work. In Heller, back in 2008, the court said the Second Amendment protects weapons in common use for lawful purposes. In Bruin, in 2022, the court reinforced that the test is history and tradition, not shifting political fear. Now, in 2025, the court has connected the dots directly to the AR-15, with more than 24.4 million rifles in circulation. This is not some niche firearm. It is one of the most popular rifles in America, more common than some of the most iconic trucks on the road. If popularity and lawful use are the test, then the AR-15 clears the bar with room to spare. That is why bans written to target it look more fragile than ever. California shows us exactly how fragile. For years, it has been ground zero for the toughest restrictions in the country. And in the case of Miller v. Bonta, the challenge to the state's Assault Weapons Control Act landed in the courtroom of Judge Roger Benitez. His conclusion: the ban was unconstitutional because it outlawed firearms that millions of citizens own and use responsibly. That ruling shook the anti-gun establishment, but they hoped appeals could overturn it. Now, after the Supreme Court's 9-0 opinion, attorneys have doubled down. They are pointing to Justice Kagan's line, saying if even the highest court affirms these rifles are lawful and common, California cannot call them illegal. It is a devastating strategy, a constitutional battering ram aimed right at the walls of state bans. The opposition's response has been telling. In oral arguments, some judges and politicians struggled to even describe the rifles they wanted to outlaw. One called the AR-15 a machine gun, ignoring corrections. Another mispronounced it entirely, referring to it as an A-15. Still others floated the absurd theory that constitutional rights might shift depending on state borders, that a rifle could be protected in Texas but forbidden in California. Imagine saying your right to free speech ends the moment you drive across state lines. It is not just bad law, it is incoherent. And yet, those are the arguments being thrown against the wall in a desperate bid to save collapsing bans. This is not happening in a vacuum. Beyond California, 10 states plus Washington, D.C. maintain their own versions of assault weapon bans. Each one relies on similar language that restricts rifles based on cosmetic features, pistol grips, adjustable stocks, flash suppressors, rather than function or tradition. The numbers expose just how disconnected these laws are from reality. In Illinois, a ban passed in 2023 swept across more than 2.4 million lawful gun owners. In New York, compliance with the SAFE Act has been dismal, with less than 15% of affected firearms ever registered. In Connecticut, of an estimated 372,000 rifles targeted, only about 50,000 were registered during the mandatory period. That is not mass compliance, that is mass resistance. Millions of ordinary people simply refuse to hand over their rights because politicians told them to. Now the Supreme Court has given them a legal anchor. Judges cannot keep pretending that these rifles are unusual or marginal. The data proves otherwise, and the court's words seal the case. When a platform is mainstream and widely owned, the Second Amendment protects it. That principle was clear before, but now it has been written directly into a unanimous opinion that every court must respect. The ripple effects are already spreading. Federal judges are beginning to take notice. Cases are being revived. Attorneys are filing new challenges armed with a clarity they never had before. So where does this go next? Expect a wave of lawsuits in Illinois, New York, Maryland, and New Jersey. These are not fringe efforts. They are backed by major legal organizations, top Second Amendment litigators, and a growing number of judges who recognize that the Supreme Court has provided clear direction. The message is simple. AR-15s are in common use. They are lawful, and they are constitutionally protected. States cannot wish that away. They cannot legislate around it. The era of ignoring the Second Amendment because of political pressure or emotional optics is ending. This ruling is more than a shield for gun manufacturers. It is a beacon for gun owners across the nation. It affirms what millions already know: rifles like the AR-15 are not exotic contraband. They are ordinary tools of self-defense, home protection, hunting, and sport. The opponents of gun rights can spin headlines, but they cannot spin the Constitution. 9 justices from across the ideological spectrum came together and drew a line. That should tell you just how settled this question really is. And so here we are, standing at the edge of a turning point. The line between freedom and control has never been clearer. If you value your rights, now is the time to stand firm. Share this message, spread the truth, and make your voice heard. Subscribe, share, and leave a comment below, because whether this is the end of assault weapon bans or the beginning of something even bigger, we are not going anywhere. We will be right here, covering it every step of the way.